This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show, a podcast dedicated to not only protecting your assets from lawsuits and creditors, but also protecting your legacy. After all, what we do isn't just for ourselves, but to create generational wealth. I'm your host, John Skabelund. Discover the answers to the top 3 questions from real estate investors who want to upgrade their wealth and safeguard their assets. This will be an ongoing series about LLC questions. So these questions, again, are from real estate investors, and I get them all the time. Question number 1, do I need an LLC for my investment property? Well, let me answer the question by asking a question. When you drive, do you wear a seatbelt? Well, most of us, we'd say absolutely yes. But when I ask, well, why? And that answer is, well, what if I get into a car accident? I want to be protected, right? But if I ask, well, have you ever been in a car accident? Well, many of us have, but I would also say many of us have not. And so if you haven't ever been in a car accident, why are you continuing to wear your seatbelt? Because the odds are that you will be in a car accident one day and you want to be protected. Well, similarly, that concept applies to real estate investment properties into LLCs. I met with a very famous real estate investor who owns more than 1,000 properties, who alleges that he's never had an issue with any of his properties whatsoever, and he does not need to put them into an LLC. And frankly, I said, you're just lucky. Just because you're lucky doesn't mean that you won't have a future event that you will regret. So from my perspective, it's not a matter of if, but when something happens. Let me share with you 2 clients. The first client I'm going to share with you had an investment property in their own individual name, or it could have even been in their living trust. I don't remember, but it really doesn't make a difference from the eyes of the law. Your living trust is like you owning it personally when it comes to asset protection. But the moral of the story is that there was an accident on the property. And in case you're wondering, there are all the craziest kind of accidents you'll hear. Just to name a few, I had a client where the tenant slipped and fell in the bathtub, injuring herself rather severely, and sued, saying that the tub wasn't safe, that there should have been slip guard. I had a tree branch fall off from the tree, crashing down on the vehicle and injuring the tenant's child. I've sadly had more tragic ones, such as smoke alarm not going off, the house burning down, and lives taken. So it obviously goes without saying that accidents happen in a myriad of ways. But when the accident occurred, the tenant sued the owner of the property. When the owner of the property is you, the real estate investor, or your living trust, then everything you own is subject to that lawsuit in a successful judgment. Again, a judgment is what the plaintiff receives after winning the lawsuit, and with that judgment, they can now seize your assets, garnish accounts, foreclose on properties. And so that LLC is what's going to protect you from the accident from that property. The tenant sues the owner of the property. If it's an LLC, it creates a shield or a layer between you and your investment property, protecting your other assets. Well, the other client that I would share with you is where the client is personally sued. I have clients that are sued for multiple and various reasons. The common car accident occurs, perhaps it's an injury at home, or perhaps your child has injured a kid at school, or perhaps it's a business partner dispute. So the question is, what happens when you, the real estate investor, is sued personally for something unrelated to the property? Well, the LLC also serves as a barrier, as a layer between you and your investment property. When the property is owned by the LLC, not by you, not by your living trust, then your personal creditor, that lawsuit, can't take your investment property away. Why? Because the property is owned by your LLC. Doesn't mean that they can't try to attack the LLC, and that's why it's really important that you're always working with an experienced asset protection attorney to make sure that that LLC is not desirable. But again, you want layers between you and your investment property. We call it inside risk when there's an injury on the property that threatens the owner. And we call it outside risk when you are personally sued and now they're trying to grab assets. We don't want your investment properties subject to your personal lawsuits. So do you need an LLC for your investment property? Technically you don't have to. You can obviously rent the property out in your own name, in your living trust. But by doing so, you are taking an unnecessary risk, a risk that can expose all of your assets to any injury on the property, and a risk that if you're ever personally sued, you are going to lose your investment property. So why take that unnecessary risk? For the nominal fee that it costs to set up the LLC properly and move that property into the LLC, it's like wearing a seatbelt. Hopefully you'll never need it, but if you do, you will be very grateful that you have it in place, because it will be too late to do it once an event that causes a lawsuit has occurred. The second question I get a lot from real estate investors is, when I buy a property, should I be buying the property in my own name or directly into an LLC? Well, if you can close directly into the LLC, that is the best way of doing it. However, it completely depends on the loan that you're obtaining. So why is it best to be able to close on the property purchase inside the LLC? Well, first and foremost, we have maximum privacy this way. Your name, if the LLC is properly structured and done right, will never appear in the public record. So we don't have this record of you transferring the property from you into the LLC. Yes, it will look like you sold the property to an investment LLC, but I rather, all things being equal, that your name never appears on the ownership of the property. Second, it also makes title insurance super clean. When you close in the name of the LLC, the title insurance will name the LLC, and so without a doubt, there's no issues as far as the title insurance being effective and extending to that LLC. That said, it is rare that title companies would ever deny a title insurance claim because you contributed to the property into an LLC. And then lastly, I believe this risk is overblown, but it is becoming more of an issue, and that is the risk of violating the due on sale clause. Now, again, in my career and those that I work with, we have not seen a lender ever take issue about you contributing a property that you own into an LLC that you own. However, this whole argument of due on sale clause violation doesn't even get raised if you close the property inside the LLC. But as I said earlier, it completely depends upon the loan. Some lenders require you to close in your own personal name. I bought an investment property just a couple years ago, and due to some weird, crazy things that happened at the last minute, we ended up having to switch lenders. And in order to close on the loan, that lender said, John, you are going to close into the loan, and then you can transfer it into the LLC. And so just realize that some loans, you are going to have to close in your name. And that is simply the reality of it. Now, that's not as ideal for the reasons I just listed, but it's better to close in your name and then approximately 30 days later, transfer it into the LLC. Why do we wait about 30 days? We don't want to ever get in front of your lender and their mortgage or deed of trust that they're going to be recording on the property. And so that's why we wait some period of time. So kind of a follow-up question, still staying on the second question of when I buy a property, should I buy it in my own name? Well, when should you be creating that LLC? Often it's not ideal to create the LLC prior to making the offer on the property. And the reason being is you're often naming, and it's best practice in my opinion, that the LLC name is after the property. When you have multiple properties, it gets confusing to be able to remember which property is in which LLC. So for my clients, typically we are going to name the LLC after the address or subdivision or something that will help the client remember which property is in which LLC. So with that said, normally you don't want to start out creating the LLC prior to even making the offer. So how do you do this? Well, the key is that you want to make the offer, ideally with your real estate holding company if you have one. But if it's just you and you have nothing set up today, then go ahead and make that offer, but make sure that it says or to its assignee. The magic language of assignee allows you to transfer the purchase contract to the LLC that you're going to create later smoothly and without any hiccup from the seller of the property. Now, if you forget this, I've never had a seller ever give my client a hard time about transferring the contract or offer into an LLC later, but I understand from realtors out there that it just makes it a lot easier as far as from the title company and closing and transferring things if you have or its assignee language. So when do you need to establish the LLC? I recommend to my clients, let's get through the contingencies first. The most important contingency typically is your inspection period. So the inspection period is usually what I find blows up the deal. That inspection may reveal that there are some problems and defects with the property that you weren't aware of that are going to be costly. And usually there's negotiation with your seller. Now, depending on how that negotiation goes, you may pull out of the contract. That's why it's contingency after all. But once the inspection and everything has been resolved and it's still moving forward, that's usually when you want to create the LLC. In most states, you can create an LLC in 2 to 3 weeks without any expedited filing fees or rush fees. So that's plenty of time in most cases for you to be able to close in the LLC. Now, what if it's all a cash deal and you have a quick closing? Well, then in most states, you can file an expedited fee and rush the LLC. That all being said, if you're doing a cash purchase with a quick closing, then you really do want to have that LLC created from the get-go. And what are you going to name it? Go ahead and name it after the property if you wish, or something generic. We can always change the name of the LLC after the fact, so don't let that stop you. But cash closing can occur quickly after the inspection of the property. So yes, for that reason, it would be a good idea to go ahead and create the LLC at the outset. So question number 3 that we're going to cover today is, where should I create the LLC? You probably have heard, and we'll talk more about it in the next episode, but why not in Wyoming or Delaware or one of those privacy states? The reason's this. The jurisdiction, meaning the law that's going to govern the lawsuit, will always be the state where the property is located as it pertains to any injury on that property. So with this said, you always want to create the LLC in the state where the property is located. If you have a Florida property, it should be a Florida LLC. If you have a Colorado property, it should be a Colorado LLC. Now, what if you have that wrong? Ironically, I have many clients who come to me with having numerous properties inside multiple Wyoming LLCs. That's not a great idea. Why? Because then you have to form register the Wyoming LLC to do business inside the state where the property is located. Say that again. If you are generating rental income or any income of any kind from the property, you are doing business in that state, and that state requires that you form register your Wyoming, Delaware, Nevada LLC in that state. Well, what that means is now you're going to pay 2 registration fees. And if you haven't done it properly, when you form register, you're blowing the privacy that you were hoping to create by establishing that Wyoming, Delaware, Nevada LLC. So it doesn't make sense. Just start out by creating the LLC in the state where the property is, and then you'll have the holding company, which often is a Wyoming LLC, to own that state-specific LLC. So I hope that this was helpful. I'm trying to keep these episodes brief. Please listen to my next episode where we'll tackle 3 more questions real estate investors ask me frequently about LLCs. And with that, we'll wrap up today's episode. Thank you so much for joining me. My goal with this podcast is to give you great, actionable content that empowers you to protect your assets you've worked so hard to build. To help me do that, I'd love to hear from you. What topics are on your mind? Are there specific strategies or legal questions you want me to cover? Please leave a comment and let me know. If you found today's information valuable, please consider sharing this episode with someone who might also benefit. Word of mouth is the best way for the show to grow. Finally, if you have a moment, leaving a quick rating and review on your favorite podcast app would be a huge help. It only takes a minute, and it makes a real difference in helping others find the show so that they too can learn from an asset protection attorney about how to protect their assets and preserve their legacy. Thank you again for listening. Until next time, stay protected.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.